Hi everyone, welcome to Legally Yours. We're here with Mann from Polaris Lawyers for this quick chat episode. I really wanted to get into the crux of no-win, no-fee agreements because I think that it's quite a different area of law. Not other specialties work in this way. So can you tell us a little bit about, what people should know, the top 5 things people should know about no-win, no-fee agreements and what they should be asking their personal injury lawyer in that circumstance?
Absolutely. I think because there are these myths and misconceptions about no-win, no-fee, it's really important to address those.
It is.
And people often approach those agreements with a lot of suspicion, and it's important to make sure that you understand the agreement. So I guess the first thing you would ask or say to a lawyer if you're presented with an agreement is you want to make sure that you understand that agreement.
Yes.
And if you don't, you have to be able to ask them for more details.
Okay.
The second thing is that some no-win, no-fee lawyers operate on a model where they charge an uplift or a loading on their costs. And basically what they're doing is saying, we believe that your case will succeed, but then we want to be paid a premium at the end for putting faith in you and in the case. Okay. Polaris doesn't charge one of those uplifts, but you'll see it in some agreements where they charge up to 25% extra on their costs.
Okay.
So that's something you can actually negotiate or get rid of entirely.
Okay.
We've scrapped them at Polaris because we think it's double dipping.
Yes.
We think we get paid well enough for believing in your case and winning the case, and that should be enough.
Okay, third.
So racing through them. So another one is that people often assume that the costs are a percentage of your payout, which is incorrect. And in Australia, it's illegal to charge that kind of contingency fee. You'll see that in the US more commonly. In Australia and in Victoria in particular, the costs we charge are based on the work that we do. The costs should never outweigh what you're going to receive. So part of the reason for that is that if we win your case, then the defendant will have to pay some of those costs. There'll be a gap that you have to pay, but that should never outweigh what you're receiving.
Okay, absolutely. Otherwise, what's the point of bringing
exactly right?
Okay.
Yeah.
And the last?
So the last one is the cooling off periods. You can sign an agreement, a cost agreement to get started on a case, have a change of heart and decide that you don't want to go ahead with the case. At Polaris, we've written our agreements in a way that doesn't force people to continue a case that they don't want to continue with. We don't think that's the right approach. And part of that means giving people extended cooling off periods. So we would say to people, if you sign, you decide you want to go ahead with the case, and then you have a change of circumstances or a change of heart, then you've got time and space to be able to say, actually, thanks Polaris, but I've decided not to go ahead. The main thing for us is we want to reduce barriers to people investigating their rights and entitlements. And so if we can build that into our agreement to give people that freedom, then we think it's worth doing.
Fantastic. Well, thank you for busting some of those myths, because I think there is a lot of misconception around that, and I think understanding that we are very different from what we see potentially on TV and those shows in America, and really making sure that you go to the right personal injury lawyer so you can avoid some of those things that do occur, could really affect what you end up with compensation at the end. So fantastic. So Nick, there's a myth out there that I'll be out of pocket if I lose my claim. Is that actually the case?
Really rarely. So if you go to court and you lose your court case, then the court will say the winner should get their costs paid. But in reality, the risks of that are so low. And what we say at Polaris is well-prepared cases are less likely to go to court. So this is a real concern for people who come to us saying, I don't have any money and I can't lose money by going through this process. We take on cases because we believe that they're going to win. We believe that people should be entitled to compensation and that they shouldn't be out of pocket as a result of investigating that claim. So we protect people against those risks as best we can.
Fantastic. Thank you.
Pleasure.